The Supreme Court clarifies on the applicability of depreciation on goodwill, a decision that experts say will act as an incentive for companies in their merger and acquisition activities, especially given that goodwill payments in these transactions have become fairly substantial. Avantika is here to take us through the implication of this very judgment.
This specific Supreme Court order comes as a big relief for India Inc. But before we get into the details of the order, let's first understand what exactly is goodwill and why did the contention on depreciation claims rise in the context of goodwill. Now, during the process of a merger or an acquisition, the purchasing company has to buy the value of the assets of the company, but it also has to pay for something known as the goodwill, which is above and beyond the assets of the company. Now, this amount basically is paid for assets such as the brand value of the company and the reputation of the company.
So let's say the reputation, the business reputation of the company, the brand value, the good customer relationships, the good employee relationships, the market share, locational advantages, all these collectively put together really represent the goodwill of a company.
The issue of claiming depreciations on goodwill has confounded corporate India for a very long time, and the law pertaining to this specific issue itself has seen a lot of contention.
Right since the inception of the Income Tax Act in 1922, for 65 years, the position of law has been fairly balanced. In the sense, if someone sold his goodwill, there was no capital gains tax on it, and the one who acquired the goodwill would not get depreciation on it. This position lasted for 65 years, from 1922 to 1987. In 1988, the law was amended and goodwill became taxable. From 1988 to 1997, for 10 years, there was an imbalance. That is, if somebody sold his goodwill, he would have to pay tax on it, but the one who acquired the goodwill could not claim depreciation on it. In 1998, the law was further amended, wherein Section 32 was amended to provide that intangible assets such as know-how, patents, trademarks and copyrights, and also business or commercial rights of a similar nature were held to be depreciable. Thereafter, the taxpayer would argue that goodwill is a business or commercial right in respect of which depreciation is allowable. On the other hand, the department would say, no, it is not a depreciable asset. This litigation has gone on for about 15 years, from 1997-98. And after 15 years, with several conflicting views of several benches of the tribunal, this Supreme Court judgment has come as a breath of fresh air.
In this specific case before the Supreme Court, the Income Tax Department had denied Kolkata-based SMIF Securities' claim for depreciation on the amount that the company had paid towards goodwill, stating that goodwill was not an intangible asset. However, the Supreme Court upheld the company's claim, stating that the expression asset should also mean intangible assets. Therefore, goodwill is an asset and depreciation can be claimed on it.
Because there was an anomaly in the law whether goodwill is depreciable or not, there was a tendency to overvalue the assets. So let us say the purchaser of a going concern was paying an extra amount for goodwill. He would prefer to show that extra amount as payment for a tangible asset or intangible assets such as trademarks, etc. He would avoid to show it as goodwill. Now, with this judgment, the taxpayer will tend to be more honest and come out and say that yes, he is paying for that goodwill. The purchaser of a particular going concern will factor into account the depreciation he would claim in respect of the depreciation in respect of the goodwill, and this would encourage the M&A activity in India.
The Supreme